Well, friends, closing statements have been made. It went over 7 goddamn hours. Eric Nelson went the guts of 3 just by himself talking. The closing statements for the prosecution were made by the lead prosecutor, Schlechter. And then the rebuttal, which is offered to the prosecution, was delivered by Blackwell. They went over everything that they possibly could, and you can probably judge by the length of this video that it's not going to be that in depth. I want to gather a bunch of different other opinions. I want to take a look at the transcript itself, because I listened, and from what I could gather, it was just a synopsis of everything we already knew. Okay, there are some sound bites that came out of the prosecution, obviously. They said, I want you to look at the evidence presented with both eyes, and then you'll come to a conclusion, and then they'd ramble on about how all of their experts would contradict one another. Because you remember, the first day, you had the karate expert saying that, oh yeah, that was a blood choke. And then they'd have another expert witness come out and say, oh no, that was a wind choke. Oh, okay, all of his force was on his back, and George Floyd died because of that. Okay, he also had a whole bunch of fentanyl in his system. Okay, but it wasn't enough because we had over 12,000 people pulled over with more fentanyl in their body, and over 600 people have survived. There was excessive use of force. There wasn't use of force. You can look at the facts, and you're not going to really draw a conclusion that is favorable to the prosecution. And something else I think that we've lost sight of is what the job of both parties is. The prosecution is to deliver a case. They are supposed to tell the jury that there is beyond a reasonable doubt Derek Chauvin is guilty of second-degree, third-degree murder, and second-degree manslaughter. What do those charges entail? Well, here are the top 2 charges. Second-degree murder is the intentional killing, but is less serious than first-degree murder, obviously. Second-degree murder in Minnesota has aspects of the felony murder rule, which is when you kill a person, during the commission of another felony, such as rape or burglary, or another charge of murder. You see how weird this is? Okay, Minnesota's gonna eventually have to adopt something new, but many other of the state have already done this, but Minnesota's one of those holdout states because they're just overall just a fucking goofy place. So a more detailed description. Second degree murder is killing a human intentionally, but without premeditation. Okay, you could see how that would work, right? Killing a human while committing or attempting a drive-by shooting doesn't fit here, but that's all right. Causing someone's death without intending the death of anyone while committing a felony other than criminal sexual conduct or drive-by shooting. Causing a death unintentionally while intentionally inflicting or attempting to inflict great physical harm on the victim while the murderer is currently restrained by the protection order, including for domestic violence or any other reason you'd normally have a protection order. And the victim was the protected third party in that order. Would that fit? Sure. Okay, that description seems apt. You can't be like some other people who are calling for first-degree murder, which would require the premeditation. That's the major point of it. There was nothing in there to suspect that those guys previously working together. Remember how this was in the headlines for a little while and then not so much during the trial at all because it was just a non-factor when you seen the entire footage or everybody's body camera angles that eventually came out throughout the course of the trial, that Floyd and Chauvin used to work together at some nightclub doing security, and though Chauvin held a vendetta against him, whatever came of that, there was no signs that those guys knew each other during the interactions, so premeditation there would be impossible between two people who are, for all intents and purposes, just strangers to one another. So, okay, second degree murder. The description would fit from the onset, but not after you take a look at the evidence, okay? He did not apply the maximal restraint hold with any attempt of killing him, okay? That was proven several times over. That is one of the prescribed holds that a Minneapolis Police Department officer is allowed to deploy per their use of force training. And just bringing that up raises reasonable doubt, if we're being honest. But what about third degree murder? A depraved heart or mind which places others in imminent danger of death and disregarding human life. Again, nothing proved that he was acting in a depraved way. Nothing would fit there. And this is, again, another one of those Minnesota-specific things. Third-degree murder has mostly been pulled off the books because it fits so much under the second-degree charge in many of another state. But this is one of the charges that's applicable, apparently, at the time of charging, but it was just never proven. Or causing someone's death by selling, giving away, or administering a Schedule 1 or 2 controlled substance. Hence why Maurice Hall could get charged with third-degree murder, because if they can prove, if there are going to be some other charges after this shit show, if there's going to be a court building left in Minneapolis by the time that all the rioting's done with, he might be charged with third-degree murder because he could be proved to be the one who provided the meth, fentanyl, whatever good time pill, whatever you want to call it. Now, this little article is pretty good, actually. So, if Chauvin is convicted of second-degree murder, which I don't think is likely whatsoever, I don't think either of these murder charges ends up sticking. But second-degree murder receives not more than 40 years imprisonment in Minnesota. Third-degree murder is sentenced up to 25 years. And you remember, he also wanted to accept a plea deal that would be for 10 years, okay? And that's important when the manslaughter charges comes up. If a person is convicted of second or third degree murder and was convicted of a heinous crime, murder in the first, second, or third, assault in the first degree, so on and so forth, and finish the sentence within 15 years of this murder, the court will mandatorily sentence the maximal possible sentence, which wouldn't apply to Chauvin because, as far as everybody knows, he doesn't have a criminal record and it wasn't brought up beforehand. So he was just a bit of a scumbag on the force, but outside of that, there was nothing criminally charged to him. The best defense to any murder charge will depend on the facts, which is what the defense is strong on, okay? In presenting a reasonable doubt. That is another thing, right? Because we defined what the prosecution is supposed to do. And what is the defense supposed to do? Is it supposed to prove Chauvin's innocence? No. It is supposed to prove there is a reasonable doubt that the defendant, I haven't watched my Law and Orders in a minute, has reasonable doubt, okay? And when we get into a couple of the bullet points from wrapping up, that's what Eric Nelson led with, okay? There is reasonable doubt on all three of these charges. Among the possible defenses are innocence, insanity, and self-defense. For second and third degree murder charges, intoxication isn't a good defense, as there doesn't have to be intent to kill, therefore there's no particular state of mind needed that the alcohol would have prevented a drunk person from creating. Sure, intoxication, but in this case, there was over 3 times the lethal dose of fentanyl in his system. There was a dude who had a bad heart. There was a guy who also had a tumor, okay? This was not a healthy individual. What about the sticky one for people? Okay, what about manslaughter in the second degree? This is the lesser charge of the 3 that Chauvin is facing, and this is also the charge that Kim Potter, who we are going to have to revisit once we get closer to the trial, because there's some very, very interesting stuff there. It still doesn't change my overall opinion that smaller women like Kim Potter shouldn't have never have been on the force. Somebody shouldn't be grabbing for something from their tool belt. They should be armed with their person. They should be able to arrest somebody without having the authority of the badge, but that is not the point for this video. But defining second-degree manslaughter is very important, because this is basically what the jury's going to be deciding on. Okay? Could they throw the entire book at Chauvin? Of course they could. Do they think that they're going to be saving themselves from a riotous conglomerate of Democrat-controlled cities in the coming weeks and months? Absolutely. Absolutely. Because the jury was not sequestered during the entire trial. They still had access. They said that they were supposed to stay off of social media. You're supposed to do this stuff, but they're only being sequestered while they are deliberating what charges will be applied to Chauvin. Very important to know that. So they know everything about Daunte Wright. It was impossible for it to not be in the headlines. And they also know, because it was also very impossible to get away from, what Maxine Waters had to say, which we will get to at the end. So their opinions are going to be swayed by what the fuck is going to happen. Everybody knew that going in, and it's only compounded, and it's only got more intense as we've come to the end of this trial. Even though Eric Nelson has done a very good job. And you know what? The prosecution has done a very good job in pounding what they can. Emotion depends on how you feel, okay? So here's manslaughter in the second degree per Minnesota statutes, the most recent update and definition of it. A person who causes the death of another by any of the following means is guilty of manslaughter in the second degree and may be sentenced to imprisonment for not more than 10 years or to payment of a fine of no more than $20,000. So you're looking at a 10-year sentence, okay? And that's also what Chauvin was going to cop to at the end of 2020 before Bill Barr stupidly nixed it. Would that have avoided anything? Probably not. Would it be out of the public consciousness right now? Probably not, but it's impossible to know. But that's something else that the jury's going to know as well, okay? Perhaps if they did their research beforehand, perhaps if they knew of the stuff that we're privy to at this time with just a simple Google search in the right direction to be pointed in, they'll look at that 10-year sentence. Look at, he was going to be able to cop to that as well. It's the lesser of the three sentences. We can't just let this guy walk. I'm not saying that's my thought process. I'm just saying that's what could be going through these 12 people's minds at the moment. So, what are the stipulations of second-degree manslaughter? By the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. So beyond a reasonable doubt, somebody creates an unreasonable risk or consciously takes chance of causing death. Okay, that hold, like we know, has been applied hundreds of times in Minneapolis, okay? It has never resulted in a death. It has resulted in 40-ish people passing out, but that's the most intense as it's been. So is that unreasonable? No, okay? What is unreasonable is letting some fucking felon drug fiend dictate the terms of their arrest. Oh man, I can't breathe. You can't put me in that cruiser. Oh man, you can't breathe. Oh, let me go. Oh, I'm just gonna kick you. Oh, don't put me down. We'll roll down the window. No man, that's not good enough. Okay, we'll put on the air conditioning. Not good enough. I'd say that Floyd was being unreasonable. The officers responding were not. Were they being unresponsible by not shoving him into the cruiser, taking him out? If he was at the precinct, right? If he would have stayed in that police cruiser, he might have died at the station because he ingested all those pills, but I don't think we'd be having the same trial. I don't think we would have been having those riots based on the death of George Floyd. I don't think it would have been that rambunctious. It was just the image of what we've seen now is a knee on the shoulder sometimes, a knee on the neck sometimes, a knee on the back sometimes, a knee on the ground sometimes. That's the beauty of a trial. Okay, you got your first impressions, and you're allowed to form a decision based on that. You're allowed to have an opinion based on what you can see with your eyes. But if you just stay steadfast to that initial position, the facts that come out afterwards, the discovery portion of the trial is probably going to put that into question if you're being intellectually honest, which you'd hope a bunch of those jurors are going to be. So the first definition of manslaughter in the second degree, in my opinion, doesn't really fit. So by shooting another with a firearm, doesn't fit whatsoever. By setting a spring gun, doesn't fit at all. By negligently or intentionally permitting any animal unknown to the person to have a vicious propensity or to have caused great or substantial bodily harm in the past to run uncontrolled off the owner's premises or negligently failing to keep it properly confined. So just know, if you have a rowdy pit bull, or if you decide that you want to keep tigers in Minnesota, if they get loose, you can be charged for second-degree murder. That's fucking hilarious. Oh, second-degree manslaughter, sorry. That's kind of funny. And then point 5 has endangerment of a child in there as well. So the only one that would potentially fit, you'd have to prove beyond a reasonable doubt that a person created unreasonable risk or consciously took the chance of somebody dying or great bodily harm. And considering the evidence we've seen from the medical examiner, no bruising on the neck, no constriction, if the body of George Floyd was presented in front of those medical examiners, they would have determined that he would have died of an overdose or something to do with his bad ticker, okay? Don't let that idea get out of your head. So I'm glad we got the legal stuff out of the way. It's the first time that we went through all of the different charges in severity. Now that we have the totality of the evidence presented in court, I don't think that any of these fit. But again, I'm not a juror in this case. I don't have the weight of this decision on my shoulders. I don't think that there's any compromise. I don't think, short of inventing a charge that would result in him being shot dead in the courtroom, Chauvin this is, would satisfy anybody. And still, there would be riots. There's going to be riots regardless. Okay? Let's cursory recap, the closing statements. If there's more information that comes out in the next couple of days, I'm definitely not adverse to revisiting this stuff because, like I said, there is just about 3 hours for Eric Nelson. There was 2.5, just about 3 hours of closing statements from the prosecution, and then a couple more hours of rebuttal from Prosecutor Blackwell. There's a lot of stuff to go over. We can go over it piece by piece, but this video would be about as long if we went through every point, but here's a good synopsis of things. Jurors in the trial of former Minneapolis police officer Derek Chauvin were presented with closing arguments on Monday and will now be sequestered until they decide whether to convict or acquit the ex-cop on 3 counts, including second-degree murder, third-degree murder, and second-degree manslaughter as well. So they're finally going to be sequestered. And what does that mean? Well, they're put up in a fucking Motel 6. They're going to be meeting for hours and hours a day until everybody on the jury figures something out, and you need a unanimous decision on all counts, okay? It can't be majority. It can't be 11-1. It has to be a majority. Or, I'm sorry, it has to be unanimous. And that's for every single count. Otherwise, if there is one holdout, which is extremely, extremely rare. So if you see somebody out there saying that, oh yeah, this is definitely going to result in a hung jury, somebody's going to definitely stand by their morals and they're going to hold out until their last breath, even if all 11 other people just want to go home and they think that they have 100% the right decision made already, that one or those 2 people are going to hold out. That is very, very, very rarely the case. So if somebody's trying to sell you a line of this is going to be a hung jury 100%, there is no way. There's like 3 or 4 people on that jury who are just going to stick to their guns. I've got some farmland in Florida for you. That's just not the case. That doesn't tend to work, okay? If this was a fair jury, selected fairly, right? We know the demographics. We know the age range that is in this jury. There are 3 or 4 people who were open to the idea of acquittal, okay? Outside of that, most of the people came in with the idea that George Floyd was a good boy who didn't do nothing wrong. Knee on the neck caused this. Not likely to change based on their demographics. These are majority Biden voters. And if you recall, 88 or 89% of Biden voters believed that George Floyd was innocent and Chauvin was guilty of murder for as high of a charge as they would apply to him. Okay? And looking at a majority of those jurors, they would fall within those demographics. I believe there's 6 white women, 2 white guys, a couple of older black people, and then a couple of mixed race as well. We went over it before the trial started, and my mind's a little foggy because there's a whole bunch of facts running around in there. But that's what the makeup is, okay? It's not indicative. It's not really a jury of your peers, because if we were going to be fair about this, it would be 5 white men, 5 white women, and a couple of different mixed race people, if you're going purely by the demographics of Minnesota, by the way, where it's an overwhelmingly white state. But back to this. Chauvin, 45, is accused of killing George Floyd, 46. I didn't realize they were that close in age. That's cool. After he, held his knee on his neck or back for approximately 9.5 minutes, the defendant caused George Floyd's death. He did. This state proved that beyond a reasonable doubt. I've got some doubts. Matthew Frank, the Assistant Minnesota Attorney General. Oh, so Keith Ellison couldn't even be bothered to show up today. So, he had to send his boy. Told jurors during the conclusion of the 3-week trial, Frank downplayed the resistance Floyd offered to officers who attempted to place him in the back of the patrol car. And that's why I said they did the whole fucking do-si-do, that he couldn't be in the back because he was claustrophobic. Disregard the fact that he had foam forming around his mouth, that it wasn't satisfactory for him to have the windows rolled down or for the air conditioning to be put on. You know what? All that stuff. No, that's totally fine. And the alleged use, no, we know that was a counterfeit $20 bill. And he was asked twice by the kid, came out like, hey man, this is a counterfeit 20. Can you either give back the smokes, give me a real 20? Can we settle this right here? But Floyd was passing in and out of consciousness. He was just a little too sleepy, as per Judge Cahill, who was in the vehicle with him. And we would get Maurice Hall's testimony, but he's too busy pleading the fifth right now because he might be getting a 3rd-degree murder charge of his own. And then the kid went back into the store, talked to his manager, and then the kid tried to come out again and reason with him. And then after all of that, then they called the police, okay? This was something that could have been settled long beforehand. And let's just even play that out. Okay, say they did settle it, okay? Buddy's already high as a kite, sitting in the driver's seat, and he was going to take off? What if he plowed into somebody? I know we're just running hypotheticals at this moment, but this is what happened. The prosecutor primarily focused on what happened after Floyd was on the ground, restrained by Chauvin and the two other former officers. Okay, yeah, because everybody has that visual in their head. Like I said, they pounded on emotion because that's what they had. For 9 minutes and 29 seconds, George Floyd begged. He begged until he could speak no more. He was saying things like, "I can't breathe." Oh, but he was also saying that after he was resisting arrest, trying to get out of his own Mercedes-Benz. And the defendant continued this assault. When he was unable to speak, the defendant continued, and he was unable to breathe. The defendant continued. When he was standing up, he was unable to breathe. Well, that's what he was saying. I'll take his word for it. But clearly, if you can talk and continue to scream and holler for like 20 fucking minutes, I don't think I'm going to be taking your testimony of "I can't breathe" seriously. And again, they're just focusing on that 9 minutes and 29 seconds because everything beforehand didn't happen. That happened in an alternate dimension, if you're the prosecutors. And also, he was still voicing his opposition for 2/3 of this. He didn't pass out, and he didn't die until about the 6-minute mark. I don't know. Doubt in my mind, but then again, I'm not in that jury box. I don't have this decision to make. Even when the ambulance arrived, Chauvin remained on top of Floyd. He added... Again, that was explained by the use of force experts that this guy has a criminal past, okay? They collected all of this information before he was put in the maximal restraint hold. They would have been able to run his ID. They would have seen his felony charges. They would have seen that he was arrested in 2019, and the virtual duplicate of this scenario happened, where he rapidly ingested drugs. He overdosed at the precinct. He was calling for his mama, saying, "I can't breathe." The entire thing happened before. And he's a big dude, and these cops were little, okay? Again, a multitude of factors here, but this is beyond a reasonable doubt. What the defendant did to George Floyd killed him. He charged, experts that the prosecution called made clear that Chauvin ignored Minneapolis Police Department policies when he spent so long restraining Floyd, and his failure to render aid once Floyd stopped breathing, jurors were told. Again, not mentioning the crowd that was forming, creating themselves as another obstacle to paying attention to the situation at hand. Again, that's whatever. Minneapolis Police Chief Medrano Arredondo, oh yes, the bald guy who looks like a bald girl, told court earlier in the trial that the way Chauvin used his knee to restrain Floyd violated department policy. Didn't. He also said Chauvin did not follow department rules on de-escalation. Frank, Assistant Attorney General Frank, said the experts made clear that Floyd died from asphyxia, or a lack of oxygen caused by the restraint applied by Chauvin and the other officers. Among the prosecutorial experts was Martin Tubin, the doctor, a lung specialist who told the court that even a healthy person subjected to what Floyd would have died as a result. Don't tell that to Steven Crowder. The defense has highlighted Floyd's drug use and his poor health, arguing those may have ultimately caused his death. That's fair to assume. And even still, remember, the defense just has to create reasonable doubt. They don't have to prove his innocence, because if you remember, if the Constitution still means anything, if the Bill of Rights is still valid, you are innocent until proven guilty. Unless you're convicted of a Me Too allegation. Then some bitch can hop out of the fucking bushes, scream rape, and your career is over. Anyways, the Hennepin County Medical Examiner's Office autopsy report on Floyd's death described contributing factors as his fentanyl intoxication and his heart disease, what I explained a little bit earlier. But the cause of death was cardiopulmonary arrest, complicating law enforcement subdural restraint and neck compression, the officer wrote. It was the stress of that interaction that tipped him over the edge, given his underlying heart disease and toxicological. My mistake. Status, Dr. Andrew Baker. Again. The Hennepin County Medical Examiner told the court during the trial. But he also made those asides that, if not given that information that he was restrained that way, he would have deduced it was an overdose. And also, he didn't show that there were any signs of trauma on the body of Floyd. I don't know. And as you can see, several city workers are raising the mostly peaceful fence with the mostly peaceful chain link and mostly peaceful razor wire. National Guard is already there, just planning how the fuck they're going to deal with all this stuff, probably by the weekend. Dr. David Fowler, the defense witness, who previously headed a medical examiner's office in Maryland, later told jurors that the death should be categorized as undetermined instead of the homicide because of Floyd's drug use and health. Fair. Very fair. In my opinion, Mr. Floyd had a sudden cardiac arrhythmia due to his atherosclerosis, and hypertensive heart disease during his restraint and subdual by the police, Fowler said. Chauvin was charged with second-degree murder, third-degree murder, second-degree manslaughter. Jurors could decide to convict him on all counts, convict him of 1 or 2 counts, or completely acquit him. Now we'll get into the beef of what the defense had to say for their almost 3 hours. Eric Nelson, Chauvin's lawyer, said during his closing arguments that the state did not prove beyond a reasonable doubt that Chauvin caused Floyd's death. Yes. Again, when I look at that video, it's tough to watch because you see a dude die on camera. I don't think anybody's accustomed to that unless they're weird, and that's fine. But it's unsettling. And at the end of the day, if Buddy would have just got into the police car and into the cruiser, carbon monoxide spewing cruiser, we wouldn't be having this trial like we are right now. Okay, you can blame a multitude of factors on this. You could blame the fucking war on drugs if you wanted to, like every smooth-brained moron out there does. Oh, if drugs weren't illegal, he wouldn't have overdosed. Yep, he wouldn't have died, or he wouldn't have been scared of the police, obviously. But that in and of itself is reasonable doubt. It was the drugs, man. At the end of the day, it was the drugs. It was the drugs, the bad heart, the tumor, the fact that he was off drugs for like 3 weeks, according to his most recent crackhead mama for short. And then the sudden rapid ingestion of that level of fentanyl. Yeah. And then what was described and what was shown in the aftermath of that really seems like something was up. What the state has to convince you is that the evidence in the case completely eliminates any reasonable doubt, or in other words, leaving only unreasonable doubt. Exactly. And that's what the mainstream narrative is right now. Unreasonable doubt. It was 100% that knee hold. It was the knee on the neck. They're still banging on this. I can't fucking believe it. It was the knee on the neck. Okay, there is no evidence to prove that there was any sort of trauma to Floyd that would coincide with the knee on the neck. Nope. Chauvin did it because he's racist and he's just hunting down people. And that's what the other side has to argue right now. That's why I'm so sick and fucking tired of listening to people. It's like, oh, if you just listen to people you agree with, you get stuck in your echo chambers. It would be fair if we were dealing with people who were on the other side of the aisle who were reasonable. There are some out there, okay? But I consider them to be on the right side, to be on the correct side. Not right, like left-right paradigm. I don't even know what that means anymore. Like if you're uncritically quoting anything from CNN, MSNBC, ABC, CBS, you're doing yourself a grave disservice because they're only giving you what they want you to know. That's why we go to the source material. And after you do this for long enough, you realize that the people who are reporting on just the source material are the people that the ones that the alphabet networks are telling you to not listen to because they're just right-wing extremists. And then just try to ask them to define what right-wing extremism is. And then just watch them power down, and you can literally hear the Windows XP power off sound just coming from one of their ears. The other one has smoke billowing out of it. But let's wrap this up. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt, Nelson added. Nelson said that Chauvin was acting reasonably, when he arrived on the scene and observed without intervening how Floyd was fighting off being placed in the patrol car. Chauvin then chose to use necessary force to subdue Floyd, said Nelson, who has said Chauvin was concerned about the actions of bystanders who became agitated by what they viewed as excessive restraint. Again, the wisdom in a mob. Nelson also argued that carbon monoxide from the vehicle next to which Floyd was ultimately restrained could have led to Floyd's death. That theory was promoted by Fowler, but contested by Toobin. But then when Toobin contested it, after Fowler was like, yeah, no, it could be, who knows? Toobin came back and was like, nope, 100%. That wasn't the cause of it because there was only about a 2% concentration of carbon monoxide in Floyd's system, and he had a 98% concentration of oxygen in his system. Okay, well, how did he die of oxygen deprivation? No further questions, Your Honor. The defendant is presumed innocent. That presumption remains with defendant unless and until he has been proven guilty beyond a reasonable doubt, Nelson said, which is the entire point of every trial. Does it always end up that way? Absolutely not. But that's what justice is predicated on. Will we receive justice? I don't know. This dude, Chauvin, could end up wearing this. And that sucks. And you could also say, oh yeah, he could also appeal up to the Minnesota Appeals Court. He could appeal up to their Supreme Court. And you can keep going on and on. No judge in their right mind would end up fucking taking up this case. No judge in their right mind would appeal this and spark a larger call, more riots. This is just going to end up in riots, so you might as well just fucking get them out of the system. If the National Guard is doing their job, if that governor, who is 100% incompetent, would actually do his job for once, there wouldn't be riots in Minnesota. There wouldn't be riots in Minneapolis. There wouldn't be riots across the country if every other blue governor would do their fucking job. But we know that that's not going to happen. This is going to happen regardless. And it's going to happen on the back of Maxine Waters' comments. And Judge Cahill had to address this because this bitch almost caused a fucking mistrial, which would have been an abortion that even a Democrat would not be for. Judge in Derek Chauvin's case, Judge Cahill calls Maxine Waters' comments disrespectful to the rule of law. ... Abhorrent. I agree. Judge Peter Cahill blasted Representative Maxine Waters, who, if you recall yesterday, was down there in Brooklyn Center at I think at that point it wasn't a riot, so it was a protest or whatever, and she had her stupid purple mask on. You can see it right just above my head. And her stupid little goggles and muttering out something about guilty, guilty, guilty. So Peter Cahill blasted Representative Maxine Waters on Monday for her remarks Saturday that there should be unrest if the jury fails to convict Derek Chauvin in the death of George Floyd in Hennepin County, Minnesota. Cahill was responding to a motion by Chauvin's defense lawyer, Eric Nelson, to declare a mistrial after closing arguments because of Waters' comments. He denied the motion, but agreed that Waters' remarks were so egregious that they created grounds for possible appeal if Chauvin is convicted of murder or manslaughter. Yeah, she really stuck her hoof in her mouth in this one. I'll give you that Congresswoman Waters, nicer than how I would describe her, may have given you something on appeal that may result in this whole trial being overturned, he said, later adding, I'm aware of the media reports. I'm aware that Congresswoman Waters was talking specifically about this trial and about the unpredictability if anything less than a murder conviction. She also said first-degree murder, which is not a charge he's being faced with, just letting you know the mental capacity of this woman. Talked about being confrontational, but you can submit to the press articles about that, and this goes to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in the manner that is disrespectful to the rule of law and the judicial branch and our function. I think that they want to give their opinions. They should do so in a respectful and in a manner that is respectful to the Constitution. Maxine Waters was around when the Constitution was signed, so you think that she should have some reverence towards it. To respect that the co-equal branch of government, their failure to do so, I think, is abhorrent, but I don't think it has prejudiced this, even though the jury was not sequestered during this time. That was also maybe a little bit of hubris by Eric Nelson, thinking that, okay, if I can prove a reasonable doubt in front of a jury that was not sequestered during the entire time of the trial, that there would be no reason for riot. Oh, poor Eric. You did a great job, and you provided a defense better than any dollar figure that you will be paid for this. But that right there was quite a statement. But also, he couldn't have anticipated there would have been a massive settlement during jury selection time. He also wouldn't have anticipated another shooting not that far from Minneapolis. Wouldn't have anticipated that Maxine Waters would have just, fell off whatever turnip truck she was on from her way from California to Washington. The Congresswoman's opinion really doesn't matter a whole lot, especially that one. So right now, the jury is actually sequestered. They're going to be deciding, they're going to be deliberating for as long as it takes. How long should we expect before we hear back from the jury? Smart money is probably about Friday afternoon. Most of these people just want to get home, get their family together. They're probably trying to send out any communication to make sure that their family gets a fucking to-go bag so they can get the fuck out of a major city for the time being. To Minnesota's credit, it is a large state with a bunch of beautiful, beautiful land that is not in the Twin Cities area, and it's going to be getting full with families very, very soon. Now that, well, even here, it's, the 19th of April, most of the snow, there's a couple little bits in just the heavily shaded areas, but most of the snow's gone. It's considerably average temperature-wise right now. I'm pretty sure it's the same in Minnesota right now, and it should be great because it's just before all the insects start blooming, so maybe take an early Memorial Day weekend. Why not? Especially if you're in every other state across the union where there's going to be big cities. And this one right here might have the staying power, and this might have the impact, especially if he ends up being acquitted of even one of the charges, that this could just go from country to country to country if there isn't a strong enough leader in the countries. And we're going to be talking about Canada at the end of the day, and I'm glad I'm in a very, very conservative, larger-ish for Canada City, so we shouldn't expect anything. I think we had one Black Lives Matter rally in our downtown square sometime last year that was well attended and like the tens of people. It just doesn't resonate here. So yeah, I'm going to be thinking this over a lot. So if we revisit it during the week, and like I said, probably anticipate something by about Friday afternoon. If they come back any time before that, if we're talking about a decision, it's going to be a massive conviction on every front. A 3-week-long trial, 3 days-ish, makes sense. Could be before the end of the week, but anticipate the later half of the week. And with that said, we got to talk about James O'Keefe suing Twitter. He followed through on his threat, and he's got a good legal team. He's got a brief little lawsuit set up, and he's got, like I said, a really great lawyer behind this, and I wish him all the luck in the world because we need to hold these propagandist, censorious outlets to task, because we can't have a situation like this George Floyd one again, where you just get the little snippets of information, and when good people want to put out the information, just exposing that what you're seeing right here is a part of a much larger situation, they should not be censored. That's what happened to James O'Keefe. That's what he's fighting up against, and that's what we got to talk about next. I thank you all very much for the gift of your time. I've been Don Consuelo. I want you to follow your gut and get after it. Take care, everyone.